Hi, my name is Trent McGregor. I'm an estate planning lawyer with Robertson Hyetts, based here in Bendigo, Victoria. No half measures. When it comes to estate planning and thinking of the complexity of farming arrangements, a simple will can be more dangerous than no will at all. Give proper consideration to all of the documents that you need to consider as part of your estate plan. A good will, thinking about your superannuation, thinking about trusts. All of these things form part of the estate plan. So I've got 30 minutes today and I want to cover a lot of territory in that time. But before that, I just want to tell you a very brief story, a true story about my family and why I do what I do. So my grandfather Bill, was a farmer in El Dorado in northeast Victoria. It's halfway between Wangaratta and Beechworth. Not a huge farm, mainly cattle. Grandpa Bill had two sons. The eldest son was never, ever going to be a farmer. He literally ran away from the farm as early as he could, and every time I hear the story, he gets younger and younger. He joined the Air Force, did his training in the Air Force, left the Air Force and joined civilian life. Very, very talented, very bright, very motivated, and he made an incredible amount of money throughout his career. He retired very early by anyone's standards. He's been enjoying his retirement for generations. The youngest of Grandpa Bill's two sons, very loyal, very honest, and always did what he was told. So when Grandpa Bill said to him, "You know what, son, you're 15, school's not really for you. You're not all that bright. Maybe finish up at school, come and join me on the farm, work full-time on the farm." He did. And then Grandpa Bill said, "Do you know what? I'm not growing the farm any more than I currently am. I don't want to. I want you to go and get a job, and I want you to bring home your wages. We'll give you some beer money, but you've got to pay for board." He did. And then the second son met someone, and that person said, "We're going to get married." And they did. And then she said, "We're going to have 3 boys together." And they did. And I'm the eldest of those 3 boys, so that's where I come in. I have very happy memories of growing up in that farm in El Dorado. Spent a lot of time there. The reason I spent a lot of time there was because my father worked there every weekend to support his aging parents. He worked in a factory during the week, and on the weekends, every weekend, worked on the farm. For a young kid, the farm was an amazing place to have lots of adventures, dams and creeks and bushland. Fantastic times. When I was about 10, Grandpa Bill came to my father and he said, "Son, we're retiring from farming life. We've spoken to a real estate agent and this is how much we can get for our farm. We'd like you to pay that much for our farm. By the way, your mother's very sick. In fact, she's dying. And so we're moving to Queensland. And you're going to need to pay that money in the next few weeks, please." My father said no to that. And that was a conversation that they never really recovered from for the rest of either of their lives. Grandpa and Grandma moved to Queensland. They gave away most of their money. The farm was sold, and it was a very sad day for my family. Now, that conversation happened 30 years ago. We're still feeling the financial and inter-family effects of that conversation. Now, I can't make anyone in this room talk to each other. But what I can do is if your family is having this sort of conversation about estate planning and succession planning, what I want you to do is learn from what happened to my family, because I think it was a poor outcome. I want you to learn from that. And I want to spend the next 25 minutes putting some other options on the table. On our kitchen table, there was one option, but I'd like to suggest some others over the next 25 minutes. So my name's Trent. I'm a lawyer for a local legal firm here. The name of the firm is Robertson Hyetts. I work in the area of wills and estates, estate planning and farm succession planning. We've got a stand here at the show this weekend. So if you think that our legal firm might be a really good fit for your solutions and problems, please come and see my colleagues. We'll be here all weekend. We'd love to have a chat. I'm a lawyer, so the fine print is very important. I'm giving some general advice today. I don't know anything about your personal circumstances. These might be good solutions for you. And please come and see us if you have questions. So, I've got a lot of ground to cover today, and I'm going to do my best to give you some really good information. I'm going to chat briefly about estate planning. And then, if there's nothing else that you take away from this conversation today, I want to tell you one really important thing about trusts. And that 5 or 10 minutes that I talk about trusts, I think I'm going to be able to teach you something about trusts that some lawyers and some accountants just don't understand. And at the end, I'm going to have a quick chat about some remedies that are available to us if the estate planning doesn't go quite right. So when we're thinking about estate planning, we're always thinking of these two questions. What do I want to achieve, and how do I achieve that? And I like to start with this approach. It works for me. It doesn't work for everybody. I start with a blank sheet of paper and I draw 3 lines down it, so there are 4 columns. And in the first column, I want to put down all the information that I know about your assets that you own solely. So this might be real estate, it might be part of the farm, it might be shares or managed funds, it might be an off-farm asset. In the next column, in fact, in the next 2 columns, goes assets that you own with other people. That might be assets that you own with your partner or spouse, might be business partners, might be siblings. Now, there's 2 columns for assets that I own with someone else. The first is assets that I own as tenants in common. The reason it's important to understand whether you own an asset as tenants in common or joint tenants is because there's a slightly different approach. In fact, there's a significantly different approach for dealing with those assets. The difference is this. For land, for assets that are owned as tenants in common, you own that portion. You own your own portion, and you can deal with your own portion of that asset independently of your other co-owners. The significance of that from an estate planning point of view is that when you pass away, your portion of that parcel of land or that asset falls into your will and goes in accordance with your will. And so if you want to give it to your co-owners or you want to give it to someone else, we need to be mindful that it's going to end up in the will. That's to be contrasted to the 3rd column, which is assets that I own jointly. Assets that I own that we own jointly are usually assets that we own between husbands and wives and spouses. The significant difference from tenants in common to joint tenants is joint tenants, everyone owns a part of the land or a part of the asset, but that asset does not form part of that person's will. So when the first person passes away, that person's share of the asset falls to the other co-owners, and it doesn't fall into the will. The last column there I'm going to talk a little bit more about in a couple of slides' time. Assets that I own in a trust. So there have been plenty of times I've been chatting to people and they say, well, I own 3 or 4 parcels of land and they're there and I own these other things. And when we dig right down into it, perhaps in their mind they own it, but what we actually find is that those parcels of land or the shares or the bank accounts, they're actually in a trust. And it's important to know that because those assets will stay in that trust even after the person passes away. It's a different discipline and it's a different method of dealing with that those particular assets that are in the trust. As I say, this approach doesn't work for every situation and every circumstance, but it's 8 times out of 10, it's a pretty good start. So when we're thinking about an estate plan, people will come to me and say, Trent, I want to do a will. I say, no worries, that's great, let's start. We always start with a will. A will always has an executor, it always has beneficiaries, so we turn our minds to those things. But an estate plan can be a little bit more than that. The second bullet point there is enduring powers of attorney. And I think that enduring powers of attorney are a really underutilised part of an estate plan. The reason for that is people just think of them as a tick and flick exercise. If I lose capacity, I want this person or those people to be able to make decisions for me. But they're actually a lot, you can make them far more useful and creative than that by coming up with some really clever solutions. So an example might be if there are farm assets and non-farm assets, if there are farming children and non-farming children, it might be the case that we can do 2 enduring powers of attorney. And the non-farming assets have the right and the ability to be able to make decisions about the non-farm assets. The farming children can make decisions about the farming assets. The third bullet point there relates specifically to superannuation. We've had compulsory superannuation in Australia for 30 years, and funds under management in the superannuation industry are growing exponentially each year. So we're seeing more and more awareness of the importance of dealing with superannuation properly. Superannuation does not form part of a will. Superannuation needs to be thought out a little bit differently. For SMSFs, self-managed super funds, and for retail superannuation, it's those 2 documents there that we really need to think about to make sure that we're dealing with superannuation effectively after we pass away. The 4th bullet point, I think, is relatively self-explanatory, but the 5th and 6th can be really useful documents as well. So sometimes we'll work through all of these sorts of things together. We'll put a will and we'll put a power of attorney in place and we'll make changes to existing trust deeds. And then the people that I'm working with will say to me, well, Trent, there's other things that I want to say. And the will is a really sterile commercial document, and the trusts is just all words and gobbledygook. There's values that I want to convey, and there's strategies, and there's other things that I want to communicate. And so sometimes in those circumstances, those last 2 documents can really come in handy. And I just want to make another point there as well. If a memorandum of wishes is on the table as being something that might be useful, there's 2 different ways it can be used. The first is it can be something that perhaps mum and dad come up with and they put it in a sealed envelope and it stays with the will. And then after they both pass away, the will is looked at and read, and the memorandum of wishes are looked at and read as well. There's another way as well, and that's where you get buy-in from the family at the time of preparing that document. So the memorandum of wishes, it might be anticipating that a particular family member might be a little bit worried, in fact, might be a little bit upset about how things turn out. And so being able to sit down with that family member in some circumstances and explain to them why you're doing what you're doing, giving them the opportunity to think and ask questions and express how they feel and working with them. And then at the end of that process, getting them to sign up and buy into the estate plan through a memorandum of wishes can be a way of, a non-legal way, sure, but a practical way of avoiding potential upset, problems and expensive disputes down the track. So I work with a lot of people that tell me that they have a trust, and then they'll say, Trent, I'm not sure I understand it. I've read the trust deed, and it's 30 pages long. And I'll be honest, I fall asleep after the first 4 pages. That's okay, I feel the same way. I feel like I'd read the same trust deed and fall asleep too. That's because no one's ever really thought about what a trust deed, a trust actually is. A trust is a set of rules. It's a relationship between 3 elements. Every trust has these 3 elements. Every trust has a trustee, that's the person in charge. Every trust has trust assets. Now that might be a farm, parcels of land, shares, managed funds, a bank account. Every trust has a beneficiary or beneficiaries. Now, the reason it's really important that we start with what a trust is and answer that with it's a set of rules for how those 3 things interact is because then we're cutting through all of the jargon that comes with trusts. And we don't worry about names like fixed trusts and testamentary trusts and discretionary trusts and intergenerational wealth trusts. I don't even know what that means. We understand that trusts are not an off-the-shelf solution. but can be a newly created, bespoke, and creative opportunity to solve problems that your family might be encountering. And look, I guess I use some of those phrases as well. I use testamentary trust and fixed trust. The reason that those phrases have built up over time is because they're shorthand for helping lawyers and accountants and the tax department understand very briefly what the rules of the trust say. But we're not bound by those rules. We can come up with a trust that says a lot of very creative things. So here are some examples of where trusts might be used. And I appreciate that your families might not be approaching any of these problems or encountering any of these problems, but these are 3 examples that have worked for me in the past. So that first bullet point there, we had a situation where the patriarch of the family had received some bad medical news. He owned all of the land of the farm. His wife was expected to outlive him, and he wanted to make sure that the next generation down, where after he'd gone, we're going to work the farm, but also provide for his wife, their mother, in her old age. Now, there were a few options on the table. One was the one that was on our kitchen table, which was, our kids, you got to buy the land. We're going to need that money quick, smart. That's option 1. Didn't like that. Option 2 was we could ask the kids nicely. We'll leave it to them in the will and we'll ask them, guys, can you please, she's your mother, look after your mother. And Dad didn't really like that either. So we went to option 3, which was to put the land into a trust. And we put some rules around the trust that said that the next generation down can farm the land and use it and generate a profit off it. But from that profit and the condition of them using that trust, that land, was that they needed to provide for their mother as well. And so I guess you might look at that and say, well, Trent, I can see some problems with that because we don't know how much the farm's going to earn in any given year. We don't know what mum's needs are going to be. But sure, these are all problems, and we worked through those. Sometimes we're looking for the least worst solution, not the perfect solution. But if there are only 3 options on the table, we're going to want to choose the best of those 3 options. The next bullet point there was in a situation, and it's a very common situation actually, where there is a number of children. There's one that's clearly going to be the farming child of the next generation. And the only asset in the estate is going to be a farm. Now, you could do a simple will and say that on mum and dad's death, the farm is going to be sold and split up. That might be a solution. For this family, it just wasn't. So what we did here was to say that the solution was that the farming son could take over the land. He was going to get the land. It was going to fall into a trust, so he could have possession of it, but he didn't get ownership of it until he'd used the farmland, until he'd paid out his non-farming children. Paid out his non-farming siblings. Again, sometimes we're just looking for the least worst solution. That third option there, ensuring that a farm is preserved for bloodline. The situation that I'm thinking of in particular here is where mum and dad are worried about one of their, not children, but children-in-law. They're worried there's going to be a family law bust up in the future. And what they wanted to do was to say, well, we want to make sure that this is our land and we want it to go down to our kids and their kids. We don't want it moving to our ex-daughter-in-law or ex-son-in-law and moving sideways in that fashion. So what we did in that case was to say that the land was to form part of the trust, and there were rules about how the capital of the trust could be used. We were locking it up for a few years, and that meant that if there was going to be that family law bust up, that we were making sure that the family farm just wasn't available for a family dispute. I've got a few minutes left today, so I'm going to try and whiz over this very, very quickly. I'll summarise the next few things I want to say by saying this. Prevention is always better than the cure. the cure is always very expensive. The cure is always very expensive. Everyone understands that it's possible to challenge a will. And if you challenge a will, you need to fit into certain categories. And you need to be either a child or a spouse of the person who's passed away. You need to show that that person owed a moral obligation to provide for you. Now, the law generally recognises that. As a husband, as a wife, we've got an obligation to provide for each other. We've got an obligation to provide for our children as well. But it's important as well to know that there's nowhere in any case or any legislation that says that you need to treat your children equally. Equally is not the same as fair. And so sometimes we need to thresh that out a little bit and understand that perhaps for a farming family, we've made lots of during lifetime provision for the non-farming children by, for example, paying their HECS debt and paying for them to go to university, whereas perhaps other family members haven't had that same provision. I know quite a lot about how much the testator's family maintenance cures cost. That's because I spend a lot of my days trying to prevent that from being a problem for many of my clients. Similarly as well, sometimes clients will come to me and say, well, I need to know more about this because I think I have a claim on someone's estate. It can cost tens of thousands of dollars. And in fact, it can cost $100,000 to go through all the processes of going to see a lawyer, getting advice, going to the court-ordered mediation, filing court forms, and then getting to the courtroom door. $100,000 in legal fees before you've even started the court case. Very briefly, I spoke about superannuation before and the fact that superannuation is starting to become a very big deal and there's a lot of money in the superannuation industry in Australia. For that reason, we're seeing more claims and challenges on superannuation as well. And part of the reason for that is because it's cheaper to claim on superannuation. It's not a court process. It's a claim directly against the manager of the superannuation company itself. So if the superannuation balance is Australian Super, the claim is not first to court. The claim is directly to Australia Super or to Vic Super or CBUS. The other point to make there is that because it's not a court process, it's private. It can be very hard to see what the other side is up to, whereas a court process, everyone's always exchanging documents. It's very hard to outmaneuver someone else when it comes to a court case. I think I do have a couple of minutes left today, so I do have time to talk about proprietary estoppel. And I get that's a very funny word. It's English. Proprietary estoppel is a way of saying that if I make you a promise and you rely on that promise to your detriment, then you've got the right to expect me to uphold that promise. And I think you can see where I'm going with this in a farming context, because obviously the farming example is that the farmer says to his son or his daughter, the farm can't afford to pay you, but I need you to do some work for me. And I need you to stick around and I need you to help me on the farm. And if you do those things, don't go and start that electrical business, don't go get an engineering degree, stick around on the farm. If you do that, I'll look after you. If you do that, I'll leave you the farm. Now that's not a contract. That might be said in the back of a tractor or over the kitchen table. But there's a court-ordered remedy that supports that promise, and it's called proprietary estoppel. I've teased out the elements there. Someone makes a promise, the other person believes that promise, that person suffers detriment. They don't go and start the electrical business. They don't insist on being paid wages for their help. And in this case, again, I have to reiterate that the cure is really expensive. So the challenge here is always, when we're dealing with a proprietary estoppel case, almost always the challenge is one of evidence. Who were the witnesses to the promise? Who was aware that that promise was made? Was it actually ever verbalized? Or perhaps it was just an intimation. Perhaps it was never said. Perhaps it was just the implication that, and the understanding that if you stick around and you support us, we'll make sure that you're looked after down the track. Similarly to proprietary estoppel, constructive trusts are judge-made law, like proprietary estoppel. So it's not legislation, it's principles developed by the court over time. And this is recognition of an ownership of interest in land. And it's really interesting because the example that I give is this. If I own land and if I let you knowingly work on the land and improve it and build sheds and fences and dig dams on it, then I've got an obligation to recognise those improvements that you've made by giving you some ownership in the property. So that constructive trust is a remedy that's available in a situation where perhaps there's only a farm and no other off-farm assets, and promises or allowances have been made. As I said a few moments ago, the costs of fixing things can be exorbitant. And I spend a lot of my time worrying about how to stop these things being a problem for my clients. I'd really encourage you, if anything that you've heard today rings true, perhaps go and see a lawyer or come and see us. We're just in the foyer of the exhibition building. We'd love to have a chat to you. We're here all weekend.